Counsel, Ms. Kaczmarek has spoken to Mr. Forbes about trying to locate and bring in the Securus representative. So let's await his appearance and testimony. Mr. Leontire, other than your request for someone from the Securus company in, I guess, in its home office or corporate headquarters, do you have any further evidence you want to present on this issue?
With respect to this question, no.
All right, then let us table this motion pending the appearance of Mohammed. And you didn't say how you didn't download it. You did. All right, counsel, I'm told that the 93 pages of all detailed evidence from Bristol have been made available to both sides in paper form. Yes?
Yes, Your Honor.
All right. All right, the next motion before the court then relates to what was initially the Commonwealth's motion for an in-court identification under Creighton principles. Creighton v. Commonwealth versus Creighton, the Supreme Judicial Court's recent decision on in-court identifications where there had not been a prior out-of-court identification. Commonwealth filed that notice. The defense filed a response or opposition, and thereafter I've received, I think filed yesterday, a motion to suppress identification evidence and testimony. Who's addressing that on behalf of the defense?
If I may first state something on the record on behalf of the Commonwealth that may govern where the defense, what their response is.
Yeah.
As the court's aware, just by way of background and history, as the court's already stated, the Commonwealth filed the notice under Creighton and Collins, essentially stating that we would not seek an in-court identification by the two surviving witnesses within a car of which the homicide occurred. After that motion, counsel filed a response to the motion in limine, where counsel attempted to get the court in limine to exclude any reference by the surviving witnesses to their descriptions of the shooter that took place over the year following the incident. It was at that point, shortly after we had that motion filed, we did have argument before the court. The court may recall that the Commonwealth submitted 2 binders containing the entirety of the statements provided by the 2 witnesses from the date of the incident up until after the grand jury, when interviewed by the Boston police detectives as to the circumstances of the identification made. There was an oral argument before the court. The Commonwealth was clear in what was brought up at our last hearing on December 7th, was that the Commonwealth never indicated whether or not we would seek to introduce the out-of-court identifications. And at sidebar, the Commonwealth indicated that our reading of the case law, particularly Creighton and Collins, and more appropriately the Johnson and Jones case, that in order to be precluded from introducing those out-of-court identifications without police conduct by those witnesses, counsel would have to file a motion to suppress, and they would bear the burden. As the court's aware, we have received the defendant's motion to suppress the out-of-court identifications, which obviously would require an evidentiary hearing. Upon further analysis of the motion as well as our evidence, it is the Commonwealth's intention not to seek to introduce an out-of-court identification procedure by the 2 surviving witnesses in the car. So essentially, the long-winded point being, Your Honor, that we're back to a motion in limine as to whether or not the Commonwealth can still elicit from those surviving witnesses their descriptions of the alleged assailant, both during or shortly after the incident, as well as what they ultimately testified to in the grand jury.
Well, and just to be clear on this, the Commonwealth is, in essence, assenting to the motion to suppress identification testimony as it relates to Mr. Ferrier and
statements of the witnesses, it's basically skin tone, race, whether or not thin face or heavier face, hat, no hat, very general descriptions that I suggest would fit many members of the population. So to the extent that defense counsel are arguing that this is a per se identification, that's just not borne out by the facts. And again, I would caution the court that to issue a ruling that would essentially preclude witnesses from stating what their current memory is as to what they saw. Again, not making identification, just general descriptions of what the assailant looked like would be a major step towards the Commonwealth not getting a fair trial and the witness not being able to state what their current memory is. As the court is well aware, counsel can vigorously cross-examine them with their prior or subsequent inconsistent statements. So that's essentially the Commonwealth's position.
Who's addressing this on behalf of the defense? Mr. Sullivan.
Yes, Your Honor. The thrust of our position is as follows, that the conditions that animate and justify the exclusion of both in-court identification and now, today, out-of-court identification would, a fortiori, exclude what we've referred to as identification testimony. So I'd like to make initially one point. Well, first by way of descriptor so that we're all using the same vocabulary. I'm using the phrase identification testimony. It is used in Massachusetts court. It is the functional equivalent of resemblance testimony. And the notion is that it is the functional equivalent of an in-court identification. So to the degree that the government wants to elicit what they're calling description testimony, our position is that they need to make a proffer as to what that description testimony is going to be. We suggest...
well, it seems to me that proffer is what is contained in the various statements of Mr. Sanchez and Mr. Freire, and those statements indicating when they were made and under what circumstances.
If that is if that is, well, I won't speak for government.
Well,
If that
I
is
just
indeed,
did.
If that is indeed their proffer, then it does in fact still raise a constitutional concern. The concern sounds in the rules of evidence as well as in due process. I will draw the court's attention to a Massachusetts case that we relied on, and it's the Massachusetts Appellate Court, and it's the case of Perez. Now, in Perez, Your Honor, the in-court identification was barred. At trial, the witness used the defendant's, referred to the defendant by name in response to a question from the Commonwealth, where I saw Mr. Perez walking down the street, or words to that effect. The court allowed it, and it went up on appeal, and the appellate court, and I'm going to quote, Your Honor, the appellate court, and this is again, this is the Perez case. The appellate court said, we cannot conclude that the judge abused her discretion in allowing the in-court identification and evidence where its admission was in accord with the case law existing at the time of her decision, adding because the defendant's trial took place before the issuance of Creighton and Collins. The point here...
Well, you would agree with me, though, or agree, I take it with Mr. Hagan, that Creighton and Collins, Gomes, another one, Bastaldo, that recently came out, none of the appellate cases directly speak to descriptive information. They speak to an identification of an individual, either by photograph out of court or by an in-person identification in court as that's the person I saw committing the crime.
I will agree that the issue presented here was not before and has not been raised before an appellate court.
Well, it may have been raised. It hasn't been addressed by our appellate courts in that recent line of cases,
Yeah,
correct?
well, to the extent it was raised in Perez, they said had the incident occurred post Creighton, then it would have ruled differently.
Well, that's simply a way of saying an in-court identification under Creighton would not be permitted absent good cause.
Yes, that's part of what it says, but these cases also stand for the proposition that when a formal in-court identification is disallowed, then you can't in-run it. You can't do the functional equivalent of an in-court identification. And if I may present the court with a hypothetical, what the courts, Massachusetts courts, are saying, and what the Fourth Circuit has explicitly said, is that there is no difference from a witness pointing to, in this case, Mr. Hernandez, or that same witness saying, "Oh, I saw a 6'2", light-skinned Hispanic male, short-cropped, haircut with a tattoo on his hand." That is the same thing, and it is the rank elevation of form over substance to conclude that the former is permitted and the latter is not. And this is the proposition that I think is implied in the current jurisprudence. These facts just haven't been presented to a Massachusetts appellate court. And I think were they, it would be just like Perez concluded that, well, geez, post-Creighton and Collins, we would have to look at this functional equivalent argument quite differently. And this is the argument we are making, that the description is infected by the same constitutional virus that prohibits the in-court identification, and now the government has conceded the out-of-court identification.
All right.
And I have one related issue briefly, Your Honor. There was a third person in the car whose name has not been mentioned, Mr. Lopez. I'm presuming the government is not intending on calling him Mr. Lopez. He's not been subject to any of these motions, and this is based on...
They wouldn't be calling him, or they wouldn't be eliciting
Would not be eliciting
description or
any description or
identification.
any other sort of testimony.
Well,
But I would
that's
ask for a proffer with respect to that, since he's not included.
Mr. Hagan, do you intend to inquire as to Mr. Lopez and anything about the identity of the shooter or the vehicle or anything
do
of
not.
that sort? You do not?
We do not.
Okay.
Very, very well, Your Honor. So, thank you for that brief aside. So the notion here is that, and I did a very long motion, 60 pages, and I don't intend to go through it all now as Your Honor has read it. But we have, just by way of example, Mr. Fieri's testimony. We have Detective McIsaac, and I'm on page 17 of our opposition and motion in limine, and this is tracked in the motion to suppress as well, that prior to the grand jury, Detective McIsaac testified that Mr. Fieri was, quote, unable to identify a particular description of the shooter other than the vehicle that pulled alongside of them and shot them, end quote. And to go from that to moderately descriptive accounts to quite descriptive accounts is the very sort of suggestiveness that the government voluntarily and rightly said we cannot elicit an in-court identification, and again, rightly concluded that we can't even elicit an out-of-court identification based on this media suggestiveness and so forth. But to allow the functional equivalent of the same does not cure the constitutional violation, nor does it cure the evidentiary violation, Your Honor.
Okay. So where does that take us on the motion that is before me? The Commonwealth is assenting to the motion to suppress. to the extent it includes or is limited to any out-of-court or in-court identification. And the motion and the language of the motion is to suppress identification evidence, which you are intending to mean descriptive information as well.
Correct.
And I have before me the two binders of information from these two witnesses as to the disclosures they've made, either to police or in grand jury or elsewhere. Need we receive any further or any evidence on this?
Yes, based on Massachusetts criminal procedure, we are still making a constitutional claim with respect to that third category Your Honor referenced, identification testimony. I'm calling it description testimony that Your Honor has referred to. And so we nonetheless have an obligation to meet our burden and take evidence in this respect.
So you want to call witnesses on a motion to suppress descriptions?
Identification testimony, correct, Your Honor.
Commonwealth, what do you say to that?
Our position is that it's not an appropriate motion to suppress. That's a motion to eliminate. It's not a suppression of descriptions. That's not something that would be the grounds for a suppression hearing with actual live testimony and evidence. If the court wanted to voir dire to assist in the concept of the motion to eliminate to prevent the descriptive testimony under a more appropriate rather than prejudicial.
Well, it's essentially the same thing, isn't it?
Perhaps.
Let's ask our appellate scholar.
Well, thank you, Your Honor. It is essentially the same thing, and that is the thrust of my underlying argument, that the Massachusetts courts have insisted that certain forms of identification evidence is the functional equivalent of pointing the finger.
I'm not sure that's true, but what they have said is under Creighton, the appropriate way for the issue to be raised is for the Commonwealth to file a motion in limine to introduce the identification, and thereafter a hearing is to be held where the defendant will bear the burden of demonstrating by a preponderance that it ought not to be permitted, that it is unduly suggestive, or that there is not good cause. Ms. Anderson, why doesn't that mean that the defendant, either under a motion in limine or under a motion to suppress, is entitled to this evidentiary hearing they're now seeking?
Your Honor, I don't believe the defense counsel is entitled to an evidentiary hearing on this point. There is a large difference between identification testimony and pointing the finger at the person in the courtroom who is the suspect who is the shooter, and reciting a version of events, which they have done and will do at trial. The proffer has been made, and the descriptions are wholly separate and are not of the same concern that the SJC has in the actual identification and of the perpetrator as the person in the courtroom, and their sureness, their.
Your Honor, one additional point, if I may, an evidentiary hearing would be appropriate if the court needed to determine some factual basis for a decision. I suggest that there's not a factual issue in dispute here. I don't think counsel's questioning the, at least, accuracy of.
Well, that's why I asked if there's a need for a hearing, or if I can rely on what's been submitted in documents.
The counsel's position is you can rely on what's been submitted.
Well, yeah, you don't have the burden. Mr. Sullivan, you're not satisfied that I should act based solely on what's in the documents?
Correct.
Okay. Now, do you have Mr. Ferrier or Mr. Sanchez here today?
The government has provided the witnesses.
That's
Are they
correct, Your Honor.
present today?
They are.
All right, let me see counsel that's out.
Your broadcast is the sidebar.
Yeah. Okay.
So you're going to have to stop recording whenever they go into sidebar.
Okay, good.
Okay, but that too, can you turn off the audio too?
Actually, no, I can.
Because it
Yeah.
turns out it's still going, because someone is listening to it.
Yeah.
Everything that's happening at the sidebar.
After the first, or during the first one.
Yeah.
Oh, is that how it was pulling? Yeah. So if we did the white noise, it wouldn't, but you can't hear. Okay.
Yeah. I can do that.
All right, he's gonna. All right, click it off.
Yeah, I can.
Okay, all right.
That's
That's okay.